Good evening, everyone. This is our webinar on DPDP and with none other than CA Narasimhan. Before I introduce and before we run the show, we need to understand that why the DPDP Act is important today. And the DPDP Act is no longer a legal topic as of now. It is becoming a business technology and governance priority for organizations across industries. Whether you are a business owner, a CFO, CIO, HR leader, or compliance professional, every organization that handles personal data has a role to play. Today's discussion is intended to simplify the practical aspects of the Act, what it means, what organizations should do now, and how to prepare in the coming months. Cover the questions that business leaders are asking, from consent and security safeguards to data breaches, children's data, cross-border transfers, and compliance planning. Not only that, we'll also look at how technology can help organizations operationalize these requirements instead of treating compliance as a one-time exercise. To me, it's more than that. And towards the end, we'll also discuss a practical roadmap for organizations that are beginning their DPDP journey. Now, I would like to introduce Sir Narasimhan, which again, whenever we are running after Sam Altman, he is the one who uses AI to the optimum level, and he is so in and out, in depth about DPDP, and he's also authoring a book on DPDP. So believe me, we are in very, very safe hands. And again, I'm pleased to welcome Narasimhan sir, who is a chartered accountant and at SNTM, partner at SNTM. He advises organizations on cyber security, privacy, governance, and compliance. And joining him is me, Harsh Agarwal. You might have received mail from me. I am the marketing manager who works with Zoho Finance. And over the last 4 years, I have been privileged and very honored to work with CAs and influencers as the likes of Narasimhan sir. So, sir, before we start, I would want to begin with the question that why should every CXO care about the DPDP Act and what makes it relevant beyond legal compliance? And sir, just one more minute. To all the attendees here today, we have a question and answer Q&A tab. Feel free to post your questions. Today, it's not just sir who's going to run the show. I'll be asking the questions that is from the ground roots. And whatever doubts you have posted on Q&A, and we will answer it towards the end. So sir, over to you. Thank you.
Thank you so much, Harsh. Hopefully you're able to hear me and see the slides clearly.
Absolutely.
Thank you so much. So, ladies and gentlemen, first of all, thank you for joining in on a Tuesday evening. Before even I get started, I think foundationally, this is one law which is going to redefine the way business is going to run, especially on a digital front. We had a law which was focusing on GST. We had a law which was focusing on income tax, and all of those scenarios, only if your income or your turnover exceeds a particular threshold, it would get attracted. But here comes an act which is applicable for almost every digital footprint as long as you are processing personal data. And let me tell you, the definition of personal data is any data which you can identify a person. So if I told Harsh, I met a tallest Bollywood celebrity who now has become my client, don't you think Harsh would be able to identify who the person is? The answer is yes. That is personal data. Now, that sort of an information, my dear friends, is basically what you and I as professionals, as organizations, we process. And we process data of our employees, which is personal data. We process data of, let us say, customers, which is personal data. We process data of even players like, vendors, which have some personal data. So the landscape of personal data, my dear friends, is extremely huge. So therefore, coming specifically to this question, what is the DPDP Act? This is an act which came up in the year 2023, and the rules were notified in the month of November 2025, and they told that you get an 18-month period. We'll talk about that a little later. It applies to any organization which processes personal data within India, period. If you are a Pani Puri vendor who is having a digital queuing system or a Swiggy ordering system where I am getting to know who the personal data and other information is, my dear friends, DPDP is applicable. Second, you are not based out of India, but you are rendering a services, right, to a typically in India, to an individual in India. It would be applicable. Today, a lot of companies are located abroad, right? I'm sure they might be using Zoho books or solutions for their accounting and other things, right? You might be having customers here in India, or you might be digitally rendering services from there, but you might be rendering here. Let's take a simple example. I know when it's a weekend, all of us want to tune to tune to Netflix. Netflix is rendering service in India. It's another matter, they may or may not have registered in India. It doesn't matter. They have, of course, but I'm just giving you an example, right? So if you're outside India but offer goods and services to India, it is applicable. And remember, even Harsh, if you don't have data in digital form, I will digitize it later. It is applicable. A classical example, all of us have a very, very nice visitor register. And who has the visitor register access? The security guard. Who is the security guard from? A third party agency. What does he do? Every day on his WhatsApp, he takes a photo and sends to you, these are all my visitors. This is digital data. Without your knowledge, the personal data, including the name, email number, is gone into your security guard's element. So the law, very, very important, especially from a CXO lens. This is not an IT problem. Many of them saying that, okay, this one complains, therefore IT should do the complaints. No, IT here is the IT department. It is a business accountability, especially the law defines what is called as a data fiduciary, who decides the means and purpose. That means an organization entity who decides why are we collecting personal data is called as the data fiduciary, and the maximum obligations are on them. Remember, even if your vendor defaulted, even if your IT team defaulted, the obligation is on the organization. So I hope now you are clear why we should, as a CXO, be worried about it.
So first of all, I think all our viewers and listeners will appreciate how simplify you are explaining. You're making it very simplified, but I know it's more than that. So following up to the next question, so what's the implementation timeline organizations should be preparing for or should be getting ready for?
If you remember, I told this act came up in 2023, but the rules came in 25, and they followed an installment based notification. Those of them who know from a corporate law, you will recollect the Companies Act 2013 was notified on an installment or a piecemeal. Similar lines, this law is notified on piecemeal. The definition and certain key clauses are notified on November 13th, 2025. 1 year from there, an intermediary called as consent management organization has been defined under the law, who tracks consent on behalf of the fiduciary. That has been notified from 13th November 2026. That is 1 year from the notification. Further 6 months, that is 13th May 2027, the entire, I repeat, the entire act is applicable. So for 13th May 2027, you have to demonstrate compliance. And if you don't demonstrate compliance, there are penalties. Unfortunately, the penalty goes up to 250 crores. We'll touch that upon a little later. That's a hot topic which for going for discussion. And never in India's history we had a law which says so much is the penalty. Of course, it is a civil offense. It is not a criminal offense. So there's no imprisonment and other things. But obviously, it is going to be a cost of running your business. You need to showcase compliance, right? So that's basically what the whole game is.
And so what is considered as a data fiduciary?
Interesting question. If you remember, I told you the predominant act is applicable for the fiduciary. What does the name fiduciary says? Trust. Any person who determines the means and purpose of processing personal data is a fiduciary. Let's take a very, very simple example. When most of you would have filled up this form in this Zoho meetings, you would have noticed that there is a small checkbox where you put a tick mark saying, I hereby consent for Zoho for the following. That means you are giving consent because Zoho is going to contact you for the, or rather reach out to you for the purpose of webinar, right? Which means Zoho is deciding the means and purpose. I am an organization as Sentium. I have my employees. When the employees come into my organization, or when we hire, or when there is a payroll which we are processing, there are a lot of personal data touch points which we have to go through. So all of these personal data touch points, when we go through, I as an organization am deciding the means and purpose of this personal data. Therefore, I am the fiduciary. What is very important is the fiduciary is a joint responsibility also in certain cases, because it says along with themselves or in conjunction with others. A classical example, when you are collecting the data on behalf of a third party on their instructions, but both of you have some sort of a role to play, it might become a joint fiduciary, right? The law also talks about few other players. One is the principal. Principal in the global language is called as data subject. In fact, data fiduciary in the global language is called data controller. If you look into ISO 27701, it specifically uses the word controller. GDPR uses the word controller, and controller is nothing but the person who decides the means and purpose. And why this definition? It is because, or why this terminology? Because the Indian law believed that when you're dealing with a principal, that is whose our personal data you're collecting, they are in some sort of a trust-based relationship. Basis on trust only you're giving your personal data, therefore the word fiduciary. The simplest example is, I am opening a bank account with ABC Bank. ABC Bank is fiduciary, I am the data principal, right? But this ABC Bank, Harsh, remember, they would obviously be using some core banking software. They may be using some SaaS application. They may be using some AI software, or they may be outsourced their payroll to somebody else. All of these fellows are called processors. Any person who processes based on the instruction, and remember the processing definition is very, very wide. It includes even viewing the data, right? So if you as an auditor ask a statutory audit, I want to have a view only access, perhaps you might touch the point of a processor. I use the word perhaps because you could also fall under the definition of fiduciary. That's an interpretation of it. Then you also have one very large player called SDF, significant data fiduciary. Very important to be clear on this terminology. The government might notify certain categories of players because they have so much volume of data, because they have so much sensitive data, because they probably deal with healthcare, probably they deal with digital data, scanned images of people. So those people becomes an SDF, and there is a humongous obligations on SDF. So if you are a CXO, maybe a CRO, CIO, whoever it is, please assess what is your personal data for you to come under this ambit. The government is not yet notified who is an SDF. But if you are an SDF, there are additional obligations. We'll cover that later. And last is nothing but the consent manager. I think I did mention consent manager is nothing but a person who obtains and manages consent on your behalf. Say, for example, you go to most of these websites, it says, I accept, right? That I accept, one fellow is sitting and tracking that entire thing through a software. That fellow is a consent manager in simple language, right? So hopefully it gave you a perspective of what fiduciary and who the other people are.
Talking about consent, so what does a valid consent will look like in DPDP then?
Now, everywhere, if you see, the law says only if you have taken a consent, you can process personal data. There are, of course, some very, very specific scenarios or an exception where it says, hey, in emergency, in disaster, in cases like that, or to a limited extent of employment, you can process without consent. In every other scenario, you have to do consent. So the consent, first and foremost, should be free. That means you should not be coerced. You should not be forced, right? I'm sure all of you remember that funny movie scenes, which all of us would have related, where the the negative protagonist with a gunpoint asks the entire property be transferred, and funny things like that, right? That is a classical example of a not a free consent. So it should be voluntary. That means I should be able to give it free. It should be specific for the purpose. Now, what is the meaning of specific? An e-commerce website is taking mobile number for what? For sending the order update. But you are calling up and selling a new product. That is not the purpose for which I've given consent. And it should be informed. That means you should be aware. Therefore, your consent notice should have everything defined. It should be unconditional. That means it should be plain vanilla. No ifs and buts and other things. And it should be very, very clear. No ambiguity. That is the core essence if a consent has to be there. Remember a few practical nuances. It should be only for the purpose for which you are processing. I cannot say forever I will do it. For all purpose I will take it. In fact, I'll give you a simple example. Today, many a times when you are signing up for some forms, schools are asking income details. Now, why is a school worried about income of the parent? I don't know if the income is higher, whether do they want to charge a higher fees? That's a different story, right? To me, I don't find a practical relevance of an income versus this. Of course, if there's a justifiable reason, that's a different story, right? So it should be collected a minimalistic possible. Second, very unique provision, Harsh. If I don't like my data with you, Harsh, I should have an option to remove my data from your system.
Correct.
Of course, you cannot remove in all circumstances. There's a regulatory guideline. Let's say RBI says you have to retain it for X years, right? In those cases, you're duty bound to keep it. Otherwise, you should have a provision. None of the systems today in our offices and organization have a capability to withdraw consent, right? Now, it is the fiduciary who has to prove that he has taken consent. Anything which is not been able to prove or it infringes these requirements becomes a processing without consent. In fact, if you're dealing with a multi regions, right, it also says your notice should not just be in English, it should also be in the 20 plus languages which is there in the 8th schedule of the Constitution, right? It should be independently understandable, and very important, they want itemized reasons. Okay, for the purpose of marketing, these are the information I use. For the purpose of loan processing, this is what I will use, right? All of these are very, very essential, right? And if you notice in my slide, I've given towards the end a very, very small point. What is the key message as a CXO you should remember, right? So these are some of the things which you should have as an evidence to prove that the consent was valid.
What should a privacy notice include then?
Okay. Now, if I have to give you consent, don't you think I have to tell you what purpose I'm actually collecting your data? Why will you give a consent? I will give you a consent only if I know for what I'm giving you the personal data. That element is called a notice. A notice in layman's language informs the principal. And if just to recollect, principal is the person whose our personal data you're processing. It could be employee, it could be customer, it could be even your vendor. So the notice shall inform the principal about what? What all personal data you're collecting, what is the purpose, how do I withdraw the consent? And you have, as a principal, certain rights. For example, you want to complain, you want to have a right of grievance redressal, etc. All of those should be mentioned. Remember, this notice should be an independent document. You cannot say, hey, here is the link, and give a very large document. From there, go into another 3-4 different documents. Difficult. The law says it is very, very important. Now, here is a small trick. Many of them keep on asking me, do I need to take consent for my historical data which I've been processing? There is no mandatory requirement like that. However, they suggest, if the act, whenever it is going to come into picture, kindly, as practical as possible, before the commencement date, issue a fresh notice that we have your personal data, this is how we are going to process. So you have an option to unsubscribe if any. So fresh consent is not necessary. But remember one thing, Harsh, Kaam Khatam, close the object. That means if you are done with the personal data, you need not or no longer need to store the personal data. Of course, you may want to retain for regulatory or certain logging purposes, but in general, once your work is over, you have to get away with the personal data.
So going on then, what is processing? Like, when is processing without the consent is permitted?
Very good question. There are specific scenarios. What the law says is called legitimate use. That means I can process personal data even without consent. A classical example is voluntary provided data. You go to a shop, they ask your mobile number for billing, and you provide the data. Nothing, no consent, nothing is asked. You just ask, they ask the number, you grab it. Voluntary when you're providing it, therefore you get an exemption. That means consent is not required. Second, government for providing subsidies, state functions, sometimes legal obligations. Say, for example, the department has to issue a notice. You cannot say that, I have not given my consent. Why are you even issuing a notice to me, right? So you cannot have such sort of questions. Court judgments, medical orders, disaster. So if you notice, the exceptional scenario are very, very minuscule. And the only thing which is in favor of an data fiduciary is for employment purposes, in order to prevent certain corporate espionage, prevention of trade secrets, whatever it is, for the purposes of employment and safeguarding the employer from loss. So which means you have a CCTV camera in your office, to a reasonable extent it is okay, but generally it is recommended that you put in some sort of a notice saying that surveillance or something on those lines. On the contrary, you as an employee or an employer, you are collecting biometric data for attendance. It is not mandatory, right? It's only ease of convenience. So therefore, in those cases, it is recommended that you take a consent. So therefore, the cornerstone or the point which you have to keep in mind is whether personal data, is it absolutely necessary for employment purposes? If the answer is yes, consent is not required. Otherwise, it is required. For example, you're asking Aadhaar card. Now, technically, Aadhaar card is not required for employment, but there is a law which says the provident fund authorities have to link your UAN with your PAN, Aadhaar, and few other things. Therefore, you are duty bound. Now, you can minimize your risk. Instead of you collecting the data, you storing it, and you giving it, give a link to your employee. Ask them to enter their PAN, Aadhaar details. So what are you doing? You're trying to reduce your risk by having that PAN and Aadhaar on your email ID. What is the problem if it is there in your email ID? You never know when something gets hacked and this information goes outside. So therefore, you have to be very cautious on this.
So good to know, sir. Actually, then what security safeguards should any organization should prioritize them?
Very good question. So far, we spoke about how the personal data comes into the organization. Now, after it has come, don't you think you have to protect it? The answer is yes. So the law says there is a minimum number of security safeguards which you have to have, and there is no compromise. And this is an indication of some sort of a system review or audits which have to be required. First, it says you need to do certain things like encryption, obfuscation. Obfuscation is basically like some sort of a masking. Some part of it is masked, some part of it is revealed. You can have a virtual token. Virtual token is what basically have a random generated ID, and everything is tracked with the help of random generated ID. Or you have to share some details to Harsh. I don't share the details of Harsh. Rather, I say to Harsh, employee ID number 555 is the person, or ID number 435 is basically the person whom we are dealing with, right? So that is an example of a virtual token. Second, access restriction. Who has access to personal data? Today, if you go to finance team, everybody has access to personal data of vendors, bank accounts, all of those things. So can I restrict that? Can I restrict access of bank account number and mobile phone number? I don't want vendors' mobile phone numbers to be, internally available. So I may want to build in certain things. I need to ensure that there is a monitoring mechanism. It is not sufficient if I have an access control. I need to have a monitoring system. I need to focus whether backups are in place without compromising my systems. I need to check whether logs are in place to record at least for 1 year. Remember, the first time the law is introduced, 1 year mandatory log retention. Of course, where you're processing personal data, non-personal data, no mandatory log retention. Then there's also contractual controls. What is this? This, if you ask me, is the most interesting as well as dangerous. You need to ensure all your processes are adhering to the DPDP requirements. And this you will enforce by way of a contract, also called as data processing agreements. So you will have to say that your processor will adhere to the basic things, and you will also have to add right to audit clause. Why? If processor defaults, penalty is on fiduciary. That means if a vendor defaults, penalty is on whom? The fiduciary, right? So this becomes extremely dangerous, and hopefully this you will slowly start implementing.
After all this multi-layered of protection, data breach does happen. In this world, anything can happen, right? Then what do we do, or what should be taken care of?
Good question. You have built everything from a security perspective, but sometimes there could be a data breach. And that, before even I go there, first question is, what is a data breach? A data breach in the context of law is not just a violation, or not just an hack or an attempt or a breach or my data moving away. It also, I repeat, remember the statement, it also is using personal data for unauthorized means, which means accidentally I send an email, instead of marking the attendees as CC, I put them in BCC. My fear is that it is a data breach, because everybody gets to know every other person's email ID. Now they can sit and process that information. I have not given the consent for it. So please think how implications could be there. So in an unfortunate event, if a data breach happens, you have to notify to the data principals without delay. You can inform what is the nature, description, measures taken, all of that stuff. Next, there is a notification to the Data Protection Board of India, which is recently formulated, and then the people under the board are being evaluated. So to them, within 72 hours, which is effectively 3 days, but remember, they don't say business hours, right? So within 72 hours, you will have to inform the entire set of information. Unfortunately, if you are failing to do this, that is failing to have safeguards and failing to notify, probably you might be attracting a penalty. Please note, this breach notification is over and above the 6-hour mandatory rule which the CERTIN has given. CERT-IN, which is the Cyber Emergency Response Team of India, which comes under MIT, Ministry of Information and Technology. They say within 6 hours, if a breach has happened, you have to notify to them. So that's an independent rule, not covered under the DPDP Act. But of course, those are specific scenarios. We will not touch upon that to avoid confusion. But this is what you need to do when there is a breach.
So all these data that the company is holding, so legally, how long can these organizations hold that data?
So before I head into this question, because it's been about 30 odd minutes since our conversation started, I would like to ask one question to the participants, and you can answer it in the Q&A window. Nothing this thing. Have you ever deleted any records in your system? I want the participants to answer in the Q&A window, because for want of any other option, you can put it in the Q&A window. Have you ever deleted any sort of a data in your system? Okay, some of them say yes.
Yeah.
Okay.
Ajay says no. Janvi Bhushan says yes. Anjana says yes.
I'm going to slightly change this equation. Have you ever deleted a client data after the purpose was completed? Or it could be any personal data. Have you ever thought of deletion of the personal data after the purpose was completed? 99%, the answer is no. You know why? They will say, hey, I want this for future reference. I want it for some other purpose. And that is where, Harsh, this next question is very relevant. The principle spoken as far as the act is concerned, erase it in typical scenarios. First, when the data principal, DP is data principal, he withdraws the consent, erase it. When the purpose is no longer valid, erase it. I hope it's clear. Withdrawal of consent, erase. Purpose is no longer served, erase it. Erasing meaning end of the story. Unless until retention is necessary. For example, a bank might be required, an NBFC is required, companies access 8 years you have to retain, etc. But the law also says for certain stakeholders, there is a timeline within which you have to purge the data. An e-commerce company with more than 2 crore users, within 3 years of the last activity, you have to delete it. That means they can retain the data for 3 years. After 3 years, if there is no activity, delete their account. Similarly, for online gaming, they've given a 50 lakh limit, again 3 years. Social media, 2 crore, again they've given a 3 years. All data fiduciaries must retain personal data, traffic data processing logs for 1 year, irrespective of what the scenario is. And whenever you are deleting the data, please inform 48 hours before erasure. So can you see this entire landscape? Don't you think has changed? Today we think it is a sort of a scenario where it could probably have an implication, right? Now again, I'm just giving you income tax department, some of them are saying requires record to be retained for 20 years, so therefore you have to retain it, right? So I will not go into the nuances, right? But the expectation is look into the scenario and then decide how you want to deal with the data.
So sir, what rights do data principals have?
Very interesting question, Harsh. Until now we were speaking, we only spoke about fiduciary. We only said if you and I are collecting personal data, what all we should do. But remember, we both are also principals at certain point in time. That means we give our personal data. You're going for a movie, you're giving it to Book My Show.
Yeah.
Book My Show in turn has to give some data to PVR or Inox.
Yeah.
They in turn give it to the popcorn vendor, because obviously you would have purchased some coupon or token. So you can imagine that there are a lot of touch points where your personal data gets processed. So what is my right? Sorry.
Digi-yatras and all, whatever we do.
Digi-yatra is another example.
Yeah.
Right? You have a Digi-yatra from the airline, the information has to come to Digi-yatra, it has to match. You have to match your Digi-yatra with UIDAI records or with whatever the other platforms. So you can only imagine how much volume of personal data is moving through the ecosystem. Therefore, what are the rights that you and I have as a customer have? First, we can ask any organization, give me what all information about me you have, right? Second, if you have my personal data, I can request you to correct it, name correction, alteration, age, number, whatever is there. I can also request for erasure. Next, if I have a grievance, I have to write to your organization, privacy at the rate, whatever, all those things. And the law says within 90 days, you need to respond. Okay. Next, right to nominate, a very unique right, which is there only in India, rest of the world, it is not clearly written in the law. You can nominate another individual to exercise some of these rights. That's typically in case of death and incapacity. And remember, this is very, very interesting. In assuming, there was a great singer and that person died and somebody mimicked that voice using AI and selling some songs. Now, how do I enforce personal rights? That person is no longer there. So the nominee gets the right on that particular thing, and that can be enforced. Look at the way that they have thought about this law, right? And of course, right to withdrawal consent, we spoke about this, right? What is very important is ensure the grievance mechanism is closed within 90 days. Otherwise, the board comes into picture, right? So therefore, kindly make sure that you have systems and processes in place so that this reaches the right audience.
Here we talked about the disease as well. You mentioned that nominees can do. What about children? They are below 18 in our country. Do they have the right to say, no, mom and dad, you can't use my data, or how does it work?
Okay. Since we are all aware, as a children, until the age of 18, generally they don't have an ability to execute something on a contractual perspective, right? All of you, I think, are aware of that. So similarly, here what the law says, any child who is basically an individual who has not completed 18 years, they cannot give consent, which means I have to give consent via my parent. Remember, one very unique provision, it says, the parent is not any random parent which you can think of. It says a verifiable parent. That means there should be a mechanism or an access to mention whether the child and the parent are actually related. So I don't want the movie style situation where somebody I hire for 2 days so that I can showcase to my principal, and that so-called parents are agreeing for everything, right? On a jovial side, while I put it up, it is mandatory to have a verifiable consent. Remember, any children data which is detrimental, for example, there are some apps which are processing personal data in order to influence the child to watch more and more videos, or in order to, there's been some of these games which have brought some sort of a psychological change on children. These are prohibited. In fact, for children data, you cannot do tracking, behavior monitoring, or targeted advertisement. Of course, there are some exceptions for the safety of the children. Like, for example, a bus which is picking up and dropping the children, you're monitoring the movement of the bus and the child, then that's fine because it's for safety purpose, right? Otherwise, you are not permitted to do that. Remember, a parent must be verified as an identifiable adult through a related mechanism. And how do you do that? You can have a virtual token. You can use DG. What is that? There's something else. Some other technology. It's failing. I'm not able to remember that word immediately. Right. So there are some mechanisms where you can probably enforce some of these things. Of course, the exemption, as I said, healthcare, education, and unfortunately, look at this. The penalty for this breach is 200 crore.
All right, so very, very interesting. I'm sure the viewers, I would request a clap or thumbs up if you are finding this session very interesting. Because for me, it's even though we know everything is there, but still, when Sir is explaining it, we realize so many new things are there. So, sir, continuing this bandwagon, who could be designated a significant data fiduciary?
Good question. If you remember, when I spoke of, I made a mention certain categories of persons might become a larger data fiduciary, and therefore the word significant. At this point, as of probably July 21st, I would say that the government has not notified any person. However, the government may notify based on the volume of data, sensitivity of data, risk to the rights, sovereignty, impact, electoral democracy, a lot of parameters. Let's say the government says any person who has more than 10,000 records. Let's say there is a organization which has a database of all farmers for giving subsidies. Probably they might be, right? So the volume and sensitivity is what the government would factor. So if you become an SDF, in addition to the traditional process, you have a few extra things which you have to do. Number one, you need to appoint a data protection officer. Just like how you have a CFO, just like how you will have a CIO, you will now have a DPO. And he or she should be based out of India, report to the board of directors or the governance. Second, appoint an independent data auditor once a year, a separate auditor. Who is the data auditor? We do not know. Hopefully, I will be eligible for it. But yes, appoint an independent data auditor. Third, you need to do a risk assessment called as data protection impact assessment. Right? It should be done on at least a yearly basis, and every time when you have done a change into your system, let's say you have introduced a new software, you have relaunched your website, you have changed the way of working, in all those cases you have to. Now, since most of them are also using AI in our work, it also says if you are using an algorithmic software that has an implication of data principle and their rights, please do a risk assessment. Right? And government might notify that SDF cannot take personal data outside of India. At this point, again, there's no restriction. And again, as I said, the clause, everything has a penalty, and the penalty is what I've mentioned as 150 crore.
What is the significance of this non-compliance penalty? Is it huge, or what would be your answer?
Unfortunately, it is huge. It is huge because this slide will summarize that for you. If you see the penalties, every penalty is very, very, very high. For example, security safeguard, just failing to have reasonable security practices, 250 crores. Breach notification, failure to inform the people as well as the DPB, 200 crores. Children data we spoke of, 200. SDF, you're an SDF. We just spoke about SDF. Failure to do that, you're 150. Any other general provision, this is like miscellaneous provision, you'll get 50 crores. My fear is when they are adjudicating you, they might give a penalty for an organization, either one or any or all of the sections. So if I sum it up, right, the top line is 650, bottom is another 200, 850 crores could be the penalty at the higher side. But remember, it is not a default penalty. The board will decide what is the nature, what is the gravity, what is the duration, what is the repetition, right? Are you a repeated offender? I'm sure you would have realized, some of them who are also on the compliance side, the regulator has its own mechanism to identify this. But of course, this can be contended. But yes, you'll have to keep in mind. But remember, if you have to contend this, you cannot go to a high court other than through a writ petition. You have to go to the Telecom Regulatory Authorities tribunal. You have a separate tribunal. You go to an appeal to them, and if you're not satisfied, then the appeal goes to Supreme Court. So you can see that the structure is a very different, and that's why I call this as a interesting times.
In chat, I see few people are demanding or requesting use case from us. So next question I'll design accordingly. See, many of our accountants are super intelligent. That's why we are all in demand, right? So from other countries also we are in demand. So cross-border data transfer is happening. So how do we control that, or what is your opinion?
Good question. Very good question. What is a cross-border? That is, can I levy my personal data and store it outside? Today, a lot of us use SaaS applications, cloud-based applications. We just subscribe to that and start using. We have never applied our mind to check where is this data hosted. Let us say we're using ABC application and the data is hosted in one country, let's say Singapore, for example, Australia, or another country. Now, this another country, for some reason, because of the geopolitical issues, for some reason, decides to prohibit usage or internet traffic from India to that country. Don't you think our entire personal data is over? Right? That is where, are you able to hear me, Harsh? Did I lose out? Can the participants confirm if you are able to hear me? I just had a small network glitch. Okay, thank you. Looks like I don't know, this screen is frozen for a few seconds. Sorry for that. So typically what happens, thank you participants. Typically what happens when my personal data is moving from one country to another country, there could be restrictions imposed. Therefore, generally the rule of law is, when personal data is actually moved outside the Indian country, you could have certain restrictions, and those restrictions can probably be imposed by the government. At this point in time, we do not have any sort of a blacklisting, right? But the only way in which it might mention is that for an SDF, they may want to have a localization, right? Or for certain categories of people, they might want to have some restrictions. That is something which you may want to enforce. But otherwise, you are free to continue this entire ecosystem as it is, right? Hopefully that gave you that clarity and the approach. But basically, transferring outside of India permitted until unless prohibited.
Understood, sir. What are the what grievance mechanism should organizations establish something of that happens?
So grievance mechanism in simple language is, what should I do in case some queries or questions come from the data subjects or data principal? So you need to have a grievance mechanism process that they say, hey, you have my personal data, I want to be deleted, whatever, all the story. Within 90 days, you need to resolve, publish this in your website, application, etc. If you don't get a satisfactory answer, you can go to the data protection board. This is similar to investor rights under SEBI, right? And you also need to implement technical and organizational measures to measure the effectiveness of that. So those are first few certain things which you need to mandatory. I'll quickly take the conversation ahead because I think we have lost Harsh there. So one of the other points which I wanted to discuss is that if I am a GDPR compliant organization, do I need to comply with DPDP? There's one common question, especially in the recent past. I'm getting it from a lot of people. And I want to clarify that GDPR compliance gives a starting point. It is not the end point. Why? In GDPR, you can do it with the help of legitimate interest where there is a business interest. In Indian law, if no consent, you cannot look at it. You cannot process personal data. Second, children's age. If the child is less than 18 years, in certain countries in GDPR, you can process personal data without parental consent. And India also says verifiable parent consent. In GDPR, one draconian provision was there, right to portability. That is, my personal data from one app to another app, one bank to another bank should be ported. India, we said we will not bring this because it is impossible in an Indian context to do it. DPO is required only for SDF in Indian context and must be India based, whereas in GDPR there is some flexibility. Data principal duties we have understood. The individuals cannot impersonate, false grievance, etc. The penalty can be up to 10,000. The consent manager definition has been defined under DPDP, not there in GDPR. Cross border, we have gone with a blacklisting model, whereas in GDPR it is a clear cut, no country you are permitted other than certain specific scenarios. And breach timeline is typically immediate and 72 hours, which you will find it, right? So maybe a GDPR is a good starting point, but it is not the end of it. Okay, so some questions are coming in. We will definitely address that. I have a couple of other questions and other elements. Some of the pointers which keep on coming. In fact, some elements where we can come in. Harsh, are you back?
So yes, I'm there.
Okay, lovely.
So can I continue with the question?
Please go ahead, Harsh.
Yeah. So we understood all what we require, and again, actually, I am knowing how we are acquainted with DPDP and Zoho books, but we would want to hear from you as you've been using this or you're knowing this product. How is our product ready for DPDP compliance?
Interesting question, because in the past as well as in this, right, one of few principles which I've always have seen within Zoho as a culture, including my personal visits, etc., is that some of these elements are embedded by design and structure, and this is a very good lesson for us, right? And I will probably use this slide as an example for us to showcase how you can scale and grow, and how some of the lessons from Zoho we can probably put in, right? Some scenarios, because Zoho is dealing with financial data, they deal with an India specific data center, which would mean tomorrow, if your organization is an SDF and requires this is something which you can look at. There are audit trails, and the audit trails are specifically saying that they're hosted in India center and certain things covered. There are encryption and access controls enabled. There is a DPA, typically there covered with all their customers. We have a DPO or a requirement which is there in the law, and that is a principle which I have seen which they have followed. And typically in the age where everybody says we want to monetize, get advertisement, etc., so personal data is not being sold, right? So this is some examples which you can probably convert into a principle for you to adhere whenever you're dealing in this particular landscape.
Can you hear?
Yes, you can go back. I can hear you.
Correct. So with 10 months down the line, with 10 months to prepare, what is the roadmap and what will you suggest should be the first steps towards it?
So as I said, May 27, the law is fully applicable, and we have less than 10 months. Let me tell you what you have to do. The next 2 to 3 months, first do gap assessments. In fact, that is what we are doing for most of our clients. Spending time to understand where your personal data is, how is it moving, how am I collecting personal data, what is the basis on which I'm collecting, what is consent versus a legitimate use, review some of the vendor contracts. So a lot of things are something which you have to do immediately. Once this is done, you have to understand what are your roadmap of action items. Is my consent taken? What do I have to do to revise my consent? How do I redraft my privacy policy? Right? Can I implement technical controls, security controls? How do I set up data principle? Right? So there is a lot of build phase which comes in. And last comes operationalize. Can we create systems and processes and training so that they are able to adhere to this? Test them against it, because you cannot test them on May 14th, my dear friends. You need to test it beforehand. In fact, most of the organizations, I'm telling you, the time is now. Start with this immediate action, build systems and operationalize. That is the only way in which you can do it. And that is, my dear friends, the summary of what I wanted to make a mention. These are some of my contact credentials. I'm absolutely happy to be in touch with you. But yes, if you have any Q&A, kindly do reach out. I see some of the questions coming in the Q&A window. I'll probably quickly take it up as it comes through. I noticed about 40 plus questions have come in, and I've noticed close to about 75 plus audience members have been on an average consistently been there. Thank you so much for your participation. I'll quickly take some of the questions. If a company is getting statutory audit or internal audit or ITR done by CA, does notice consent has to be taken? Yes, you will. The CA or to whomever who's processing the personal data, it is recommended a consent is taken. So as a CA office, kindly make sure that the consent is taken. Okay, so that is the first thing. If company keeps shareholder data as per SEBI, does consent need? Very interesting question. Ideally, yes. So what you could do is you can mention these are requirement under Companies Act as well as Securities Exchange Board of India, but still I will have to take consent, because the law says in India you can process personal data only if consent is taken. In GDPR, legitimate purpose, you could make use of it. Here it is not possible. If some of a data is individual, is publicly available, then does the provision of the law applicable? I already clarified. If you are posting something on social media, including your contact Aadhaar number, you cannot typically do that. Is official email ID personal data? Yes, because I can identify a person through that, but the risk is much lower. If I'm deducting TDS of a proprietor, is consent notice needed? Yes, as part of your vendor agreement, you will have to enforce it. Act is making certain elements of RTI weak. Can the new law being challenged? At this point in time, some contentions have already gone before the Supreme Court. Let's see how that comes up. Can I take consent if we process and keep personal data? I think we spoke about this. Law provides huge amount of penalty, but why there is no provision of compensation to data principal? Interesting provision. You can go under the class action suit, but that is a difficult thing for you to justify. Okay, that might be a challenge. In India, we don't have effective class action suit provisions. Only limited extent in Companies Act it is there. As a principle, as a country, we do not have class action suits. I'm in CA in practice. We update the client on DPDP Act. They are not much bothered. Yeah, so I think we have to build through awareness. You have to bring this penalties. You have to bring that implications. You have to bring the vendor ecosystem. That will give triggers for you to get started. In employee-employer relationship, anything which is necessary, only then it is permitted. If it is casually obtained, additionally obtained, etc., personal data, you have to take consent. Is there any test to decide whether personal data is treated as voluntary? Very difficult. For example, you will have to decide on a case-by-case basis. You cannot say that every scenario personal data is how do I put it? Voluntarily given. The test has to be very, very minuscule, and you have to be very careful in deciding that. So I think I've answered.
So you have
Yeah, is it mandatory to know the 22 languages? Right, so the framework says so. Especially you're dealing with certain regions, then I think it is recommended that you have it in multiple languages. Do we need to make changes in existing NDA from employees? Yes, recommended for you to make some changes. Can DPO also be grievance officer? Yes, you can be, no problem. Cross-border use case, I gave an example that I'm hosting a SaaS application which is in Singapore or some other country where my data is residing there. What else do I have? I have sold the CRM kind of a software to company X. Company X put the data of their lead ticket on my software. What kind of consent I need to take from company X? What kind of this thing? It's a fairly complex thing. Write to me, I will be able to explain. But in summary, if you're a product company, the compliance is very different. You need to enable privacy by design, and you need to tell your customers that they have to be responsible for obtaining consent. You're only a platform. It is like you're like a Zoho meeting, you're like the Google or Microsoft of the world. Any DPDP professional tool is there? Unfortunately, no. What should a DPO or a compliance professional keep in mind when recommending algorithmic software? Right? Okay. So when you're looking at algorithmic software, please look at risk. Look at what is the risk you're exposed to, what is the implication, especially from a personal data perspective. I have sold CRM. I think I already answered this. Will government assess on the mechanism? Okay, there's no mechanism where the government will assess, but the government can always audit. The government can always ask questions. It could always issue notice, etc. Can CISO be a DPO and a grievance officer? No prohibition at this point in time. Data discovery tools. There are hundreds of tools. You can just go at Google search. You will probably get that.
Yes.
Okay.
I think, yes, sir. I think we are through with all the questions. And first of all, sir, thank you, and thank to all of our listeners who took out their.
Not sure if I heard you, Harsh. Again, I think we lost you.
It on his LinkedIn channel, so we can revisit the video again. And I apologize for any technical glitch that happened. That is something that is beyond our control, though we try to be as smooth as possible. Sir, thanks one again. You have simplified this problem for us. And worry not, viewers, we will be coming back with Sir and his team in the forthcoming month onwards. So stay tuned and keep yourselves updated. Sir, any word of thanks from your end?
No, I think it is my humble request is that you need to get started, create awareness, spread the word. It is not that one way you will be able to do that. The whole problem is the entire business has to be redesigned and restructured, and it gives a fresh mind and a perspective. So I think this is a right time for you to re-engineer business, probably put in more controls, probably bring up more systems and practices, and help organization or your own organization to be compliant in the long term. Thank you so much for being a very, very patient audience. My contact details and credentials are there, and I'm happy to be in touch with you. Thank you so much.
Thank you, sir. With your permission, then we are closing this webinar. Again, thank you all for joining.
Okay, bye-bye.